Welcome to the first edition of This Month in Payroll for 2023. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory Practice, and I hope everyone had a great end to 2022 and that your year has started well so far. Last year finished with a bang, with the passing of the Secure Jobs Better Pay Bill and the ATO issuing its draft ruling on employees versus contractors, following last year's JAMSEC and personnel contracting cases. In this month's edition, we will explore both of those developments, as well as the impact of the Wipro case, which redefines continuity of service periods for long service leave in New South Wales, and also the introduction of the new paid family and domestic violence leave entitlements. But first, the Secure Jobs Better Pay Bill. On the 6th of December 2022, the Secure Jobs Better Pay Bill received royal assent, marking the most extensive industrial relations reform seen since the introduction of the Fair Work Act some 13 years ago. The bill introduces changes to enterprise bargaining and industrial action, a focus on gender pay equity and job security. It adds protection for employers with regard to flexible work arrangements, and it abolishes several commissions, including the Australian Building and Construction Commission and the Registered Organisations Commission. The changes introduced in the bill are staggered over the next 12 months. Those that have immediate effect include the changes to enterprise bargaining. The changes to enterprise bargaining have not worked in the employer's favour. Unfortunately, the promised simplification to the boot rules was wound back as a last-minute concession to ensure passage of the bill. As a result, boot analysis must still consider patterns, kinds of work, and types of employments that are reasonably foreseeable, meaning the boot analysis is still a complicated likely scenario calculation. The other change to the boot rules is that the Fair Work Commission will now have the ability to review the boot analysis at any time during the term of the EA, where there are new employment circumstances, kinds of work, or types of employees which have not previously been considered. This change will increase risk for employers, as they can no longer rely on the details agreed through the EA process to remain relevant for the entire term of the enterprise agreement. The other change to enterprise bargaining is that employee bargaining representatives will now have the power to initiate bargaining where an enterprise agreement has expired, rather than relying on the employer, subject to certain limitations. Pay secrecy is now prohibited. Employees, including former employees, now have a right to ask other employees, and even employees with other employers, about their pay or their employment terms and conditions. There are some obvious issues to manage with this. First, while employees can't be forced to give their salary information to another employee just because they got asked to, employers still need to consider how to support employees who don't feel comfortable disclosing their remuneration. Secondly, greater transparency may lead to questions regarding relative parity within an organisation, across roles and grades, as well as gender, which will need to be managed. Employers will need to review their template employment contracts to ensure they do not include clauses which prevent employees from discussing their pay. This would include removing the private and confidential heading that many contract letters include. Note that there is a 6-month grace period before including these clauses in contracts of employment will be a breach in the Fair Work Act. And finally, wording in remuneration policies and messaging at remuneration review time will also need to be considered. Changes that are deferred but still need to be prepared for include flexible working. After 6th of June 2023, when an employer receives a flexible work request from an employee, they will have 21 days to meet with the employee and either agree to the request, agree upon an alternative change to the employee's working arrangements, or provide in writing the reasonable business grounds preventing the accommodation of the request. Failure to make a reasonable attempt to accommodate the employee's request can now be taken by the employee to the Fair Work Commission for mediation. So given this new environment, employers will need to update their employment policies and processes to allow flexible work requests, prepare templates for management on how to respond, provide policy support around flexible work, and, to the extent not already done, consider how they set up their business to successfully accommodate flexible working. Another change is fixed-term contracts. Employers will be prohibited after the 6th of December 2023 from engaging an employee on a fixed-term contract of more than 2 years or on 2 fixed-term contracts that cumulatively exceed 2 years. There are some exceptions, including apprentices and trainees, seasonal work, employees who have specialised skills required to complete a specific task, and employees who qualify as a high-income employee. These changes could significantly impact employment practices in sectors that use fixed and maximum term contracts, such as education, IT, and mining, and will require the introduction of processes to monitor the awarding and renewing of contracts. For example, training and information sessions should be provided to staff responsible for recruiting and onboarding employees. System-based solutions may need to be introduced or controls introduced to flag potential breaches. Another change that is coming is the sunsetting of zombie agreements. Zombie agreements are certain agreements that were made before the Fair Work Act commenced in 2009 and that still continue to operate. Unlike enterprise agreements, zombie agreements were not required to be compared against modern awards, meaning that employees covered by zombie agreements may have less beneficial terms and conditions of employment than they would otherwise receive under the relevant modern award. These agreements will automatically terminate on the 7th of December 2023 unless an extension request is made. By the 6th of June 2023, employers who operate under a zombie agreement are required to notify affected employees that they are covered by a zombie agreement and that the agreement will terminate unless an application to extend the agreement is made to the Fair Work Commission. After a zombie agreement has ceased to operate, minimum pay and conditions will typically be set by the relevant modern award, unless a new enterprise agreement is negotiated. A lot of the attention coming out of the Secure Jobs Better Pay bill has been focused on the changes to enterprise bargaining, the significant changes to multi-employer bargaining, the proposed changes to the boot. However, the legislation will impact many aspects of the employee lifecycle, from hiring practices to remuneration disclosures to how we work. We will continue to monitor and share best practice tips as we work with employers to respond to this new environment. Last year, we spoke a lot about the importance that courts were placing on the terms of a contract in determining employment matters. This was on the back of several court decisions, including Workpac versus Rosato, and in February of last year, 2 High Court decisions, JAMSEC and Personnel Contracting, which both dealt with the perennial employee versus contractor argument. In ruling on the JAMSEC and Personnel Contracting cases, the High Court effectively found that the case which has set the employee versus contractor precedent for the last 20 years, Varbu versus Hollis, has been generally misunderstood, and that when deciding whether a worker is an employee or contractor, one needs to consider the contract primarily, rather than looking at facts and circumstances from conduct across the entire engagement. In December, the Tax Office released draft ruling TR 2022/D3, advising their view on who is an employee for PAYG, and by extension SG, purposes. The ruling recognised that to determine the nature of the relationship between a worker and an engaging entity, it is the terms of the contract between the parties which are to be taken into account. The contract itself may be in writing, oral, or implied from conduct, but regardless of the form that it takes, the assessment should consider the intention at the time that it was entered into. So, what are the terms under a contract which indicate an employment versus a contractual relationship? Importantly, it is not simply the label. The Tax Office is clear that a contract will be a sham if it is not a legitimate record of the intended legal relationship between two parties, and it is evident that both parties intended their relationship to differ from the written contract. Rather than the label, it is factors such as control. The more control the engaging entity can exercise over how, when, and where the worker performs the work, the more likely the worker is going to be an employee. Integration, where the worker performs services in the principal's business and as a representative of the principal's business, the worker is more likely to be an employee. The ability to delegate work. Workers with the power to delegate work are more likely to be contractors. Results. Employment contracts are more likely to pay workers by reference to hours worked, activities performed, commissions, rather than a fixed sum paid on completion of the job. Tools and equipment. The provision of specialised equipment and tools by workers, or the incurring expenses and overheads without reimbursement, may be an indicator that the worker is a contractor. However, the scale and cost of the tools and the equipment must also be considered. And finally, risk. Where a worker bears little or no risk, they're more likely to be an employee. The draft ruling reinforces that employers must ensure that the contracts used to engage workers accurately reflect the nature of the working relationship. Long-standing contractor relationships should be reviewed to ensure that they are still operating consistently with the initial contract. Having a good document management system to maintain access to contracts is also an essential control. Finally, the draft ruling also reiterated the ATO's view that where a worker does not contract directly with a business, but instead engages through an interposed entity, a partnership, company, trust. This contract cannot be an employment contract, as no contractual rights and obligations exist between the business and the individual worker. A different conclusion may be reached if the worker is also a party to the contract. This guidance provides a level of certainty to employers. Where contractors are legitimately engaged through interposed entities, PAYG withholding and SG should not apply. Note that payroll tax may still apply. Redefining service periods for long service leave in New South Wales. In New South Wales, employees become entitled to long service leave once they have completed 10 years of continuous service with the same employer or related corporation. Continuous service has been assessed to include any period of employee service that was substantially connected with New South Wales. Where an employee is seconded or transferred to Australia from a related employer, their service period with that overseas related employer has traditionally been counted towards the 10 years of continuous service. On the 14th of December last year, the New South Wales Court of Appeal overturned this traditional view in Wipro versus New South Wales. The background of the case is this. Mr. Rawat worked for Wipro in India from February 2009 to February 2015. He was then seconded to New South Wales from 2015 until November 2019. Although he worked in New South Wales for less than 5 years, his employment with Wipro exceeded 10 years in total once the Indian service was added in. The issue then was whether Mr. Rawat's service in India could be counted as part of his continuous service for New South Wales long service leave purposes. In assessing continuous service, the New South Wales Court of Appeal found that there must be a relevant connection with New South Wales at all times during the continuous service period. For example, performance of service in New South Wales provides clear evidence of a relevant connection. Similarly, employees working outside of New South Wales at the direction of a New South Wales employer, for example, outbound secondees, are also likely to have a relevant connection. Employment under a contract drawn up in New South Wales may also connote a relevant connection. Accordingly, as Mr. Rawat's employment in India had no relevant connection to his subsequent employment in New South Wales, the court found that his service period in India should not count towards continuous employment. The reasoning behind this decision aligns New South Wales with Victoria, following the Victorian Court of Appeal's decision in the Infosys Technologies case of 2021. As such, periods of service which are not connected to New South Wales employment are no longer likely to count for long service leave purposes. Given this decision, employers in both New South Wales and Victoria should reassess their long service leave practices to ensure that they are not over-accruing liabilities for their employees. And finally, a reminder that the new paid family and domestic violence leave, FDV, entitlement will shortly take effect. From the 1st of February 2023, all employees in the Fair Work system, including part-time and casual employees, will be entitled to 10 days of paid, non-cumulative FDV leave in a 12-month period. Small business employers, less than 15 employees, start FDV on the 1st of August. If a workplace already provides employees with paid FDV leave entitlements in their enterprise agreements, employment contracts, or workplace policies, then the entitlement should be assessed to ensure that it is at least the minimum entitlement under the National Employment Standards. An employee can take paid FDV leave if they need to do something to deal with the impact of family and domestic violence, including, for example, making arrangements for the safety of themselves or a close relative, including relocation, attending court hearings, accessing police services, attending counselling, attending appointments with medical, financial, or legal professionals. Full-time and part-time employees can take paid FDV leave at their full pay rate for the hours they would have worked if they weren't on leave. Casual employees will be paid at their full pay rate for the hours they were rostered to work in the period they took leave. Full pay rate is the employee's base rate of pay plus any incentive-based payments and bonuses, loadings, monetary allowances, overtime, penalty rates, and any other separately identifiable amounts. Importantly, while employers do need to keep a record of leave balances and any leave taken by employees, payslips must not mention family and domestic violence leave, including any leave taken and leave balances. This is to reduce the risk to an employee's safety when accessing the leave. The Fair Work regulations suggest that the amount could be recorded on the payslip as paid as special leave, miscellaneous leave, or leave-other. Before we wrap up, we have flagged for some time now that a heightened focus on gender pay gap reporting was coming, looking to overseas territories for experience. The Australian government has made it clear that it is pursuing its mandate to improving gender equity in the workplace, and we're already seeing the start of the heightened focus that we were predicting. Therefore, I am pleased to announce that our first Payroll Leaders Forum for 2023, held on the 15th of March, will feature Beth Shaw, who leads our diversity, equity and inclusion practice. Beth will participate in a panel who will consider the current and developing gender pay gap reporting requirements and discuss how employers can respond to this. We have a fantastic panel of speakers lined up and invite you to register by following the link on your screen. And that's it for a very big edition of This Month in Payroll for 2023. If you would like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in payroll and have a great year in payroll. Thanks, everyone.